Good evening and welcome to Law and Order, brought to you exclusively by Channeleye. Last week we took on the subject of financial products, that is to ascertain as to what products are available through banks and financial institutions for us, the general public, that we require for various needs, including the starting up of a business or a company, or even something as simple as purchasing a car or a piece of land. We analyzed the various types of financial products that are available to us, and tonight we will be going much deeper into that, and we'll be analyzing what rights and obligations we have when we enter into these transactions with these banks and financial institutions. And once again, to assist us in this area of law is Mr. Chanaka Jayamaha, who counts more than 14 years in the legal practice and specializes in commercial disputes. Thank you, Mr. Jayamaha, for joining us once again in the studio. For the benefit of the viewers who couldn't join us last week, could you just recap for us some of these products that are available in the market? And if you could also touch upon that very important point that you made last week on the importance of knowing what your need is and matching that with the product that you end up obtaining from the bank or financial institution.
So, as we spoke of last time around, some of the products that are on offer, the more common products are the loans. You get leases and hire purchase, which is more connected to vehicles, and you get factoring as well, and you can also go in for perhaps an overdraft facility as well. So, those are generally the products that are on offer, and like we discussed last time around when we had this discussion, it's important to know your rights at the point you get into one of these facilities. Now, for instance, if you look at, say, leases and hire purchase, most parties are not really aware what happens if they really can't repay that debt. They feel that a common misconception is that when they've taken a facility over a vehicle and they can't pay that facility, if they go and return the asset or the vehicle, that everything's over. They feel that, okay, now we've returned the vehicle, so there's no obligation to pay. And then when perhaps the finance company or the bank litigates, they cry foul, not realizing that you don't relieve yourself of the liability because you have undertaken to pay those rentals as such. And as such, you need to know exactly what you're getting into. As I said, you need to realize that it's not just about applying for a facility and being happy at the point you get the facility, but also analyzing and getting advice as to what you do when something goes wrong, or in other words, when you can't furnish whatever monthly payments or other payments that you need to make. So that is one thing, and you also need to figure out what your real requirement is. Now, as soon as you go to a bank or a financial institution and you say, listen, I need money and etc., you need to also analyze your repayment abilities as well. Now, assuming you're into agriculture, for instance, and assuming your crop is such that your income is sort of an annual thing or a biannual thing, then your payment capability also will be a annual or a biannual thing. So, then should you be getting yourself sort of pegged down with a facility which you need to pay monthly installments as such. So, you need to really get that message across to the company or the bank, and you also need to analyze, okay, what can I pay, how much can I pay, what is going to be my income, if I pay this much, can I sustain myself with the rest of my business, etc. So, you really need to analyze that aspect as well. And another product we spoke of was factoring. Yes. And now most people think, again, when you factor a debt to a company, you relieve yourself of the liability in relation to that individual debt. No, your liability remains. Assuming your customer doesn't pay you, you're still liable for that debt.
Absolutely.
So, going by that example I mentioned, if you factor a debt of 1,000 rupees to a company and you get, say, 950 rupees upfront, You assume that the transaction, that individual transaction is complete. But what you don't realize is if your customer doesn't pay that 1,000 rupees, you are still liable for 1,000 rupees together with interest until that amount is paid.
Yeah.
So, it is not a situation where you factor a debt and you say, well, I have sold this debt, now it is your responsibility. The responsibility still remains in the customer in the form of the party who takes the facility to ensure that the payments are made. So, as I said, you need to understand what you are really getting into, and as I said, most people do not understand or analyze or get advice in relation to what happens when you can't pay or when something does not go according to plan. So, that is the aspect that needs more focus in relation to parties who get facilities.
So, in terms of all these facilities, at the end of the day, the grounds or the basis on which the company or the bank enters into this transaction with a customer, the terms are crystallized in what is called an agreement, particularly where hire purchase and lease and even factoring is concerned. But the problem is, more often than not, we do not take the trouble to read these agreements before we place our signature there. Now, there is also this difficulty where banks and financial institutions sometimes do not provide us with these agreements. Now, in such instances, does the customer have a right to demand that they see these agreements before they sign it, or at least if they are, for example, not conversant in English, but the agreement is in English, are they able to seek assistance from somebody at the bank or financial institutions to explain the vital components of this agreement to them in the language that they understand? What are the rights that are available to a customer?
That is a very fundamental right which people forget. People assume that an agreement, people complain that, okay, now assuming they default, they say, I didn't get a copy of this agreement. Then assuming that they are in default and matter goes before court, a common defense is, well, I didn't understand what I got into,
yes.
because perhaps the agreement was in English and I couldn't really understand what was in that agreement. But the fact of the matter, or the fundamental concept, is that when you are entering into a contract, you have every right to know what you are getting into. You have every right to know what is in that agreement. You have the right to get it explained in your language, and you also have a right to get a copy. Now, that is more of a fundamental right in the form of in terms of contract law, which means that if you are entering into a contract, you obviously need have the right to get a copy of it.
Absolutely, yes.
And what also is interesting is when these people, when defaulters come before court, they say, well, I was forced to signing this, or I didn't have the power to really negotiate. Perhaps that was true, but what they also don't realize is no one was holding a gun to their head and sort of forcing them to enter into any contract. Assuming you don't want to get into that particular contract, you don't have to. Assuming you don't understand what's in that contract, you don't have to sign that either. And assuming it doesn't meet your requirements, no one's forcing you to get it. And there are enough and more banks and finance companies who are willing to offer you a product, a financial product on your terms. And they are willing to be as flexible as they possibly can, because you are ultimately the customer. So, you must understand that right at the point you are entering into a contract, rather than complaining at the point you are in default, because then what will be highlighted even in a court of law is the fact that you are in default. So, the fact that you haven't got an agreement, the fact that you didn't understand it, it becomes somewhat ancillary to the main issue, which is the fact that you are in default. So, as I said, the most primary issue, that people don't realize is that at the point you enter into a contract, you need to demand and say, I need to go through this. As I said, no one's holding a gun and saying sign it. So, then if you want to go through it, you should say, well, I want to go through this agreement, I want to go through it, I want to get some advice from my lawyer, I perhaps want to get it explained in more detail because of the complicated terminology in it, or perhaps I need to get some advice from someone who is more conversant in it. And perhaps I need to even discuss it with my accountant, who will perhaps say, okay, based on this agreement, these are the implications from an accounting point of view. So, without really doing that, there is no point complaining later. So
once you are in default
exactly.
and find yourself being.
So, it is very important that you assess that agreement in every manner possible. As I said, from a legal point of view, from a financial point of view, you need to understand it, you need to assess it and see whether that is what is best suited for you.
We need to give more value, place more value on our signatures, don't we?
Of course, of
We
course.
can't just sign on a dotted line and thereafter be surprised when we are held accountable for what we have signed for. Now, Chanaka, another common misconception amongst most people is that guarantors are not as liable as a principal debtor. There is this assumption that a guarantor is required to just, you know, pad up the agreement just to give it a little bit more security, and it's just a namesake. You know, that person doesn't really play a very vital role. Would you agree with this, or is there any advice you can give our viewers when it comes to signing as a guarantor on a facility?
Most guarantees, if you look at the terminology in it, you are liable in the same manner as a principal debtor. Most people are coaxed into becoming a guarantor into a facility by the party taking the facility, saying that, listen, you are going to beef up this whole transaction by being my support factor by signing this. So, most people blindly sign it. Like you mentioned before, you need to place more value towards your signature. You need to, if you are called upon to sign as a guarantor, you yourself need to assess what you are getting into. What are your rights, liabilities, to what extent will you be liable, if something goes wrong, to what extent you can be made liable, etc., etc. So, what happens commonly, of course, is that most people don't analyze that aspect. They just blindly sign and then they say, well, I thought I was merely a witness to this transaction.
Yes,
that's
right.
a common defense, which is not going to hold much weight. Also, they assume that by signing in a guarantee document, be it a bond or otherwise, that you are merely being a sort of a second party to this agreement. You are not. If you look at most of the terms of these guarantees, you are liable as a principal debtor. And if you properly analyze it, most banks or financial institutions get the right to even go against the guarantor first, even without going against the principal debtor. So, once again, defaulters tend to cry foul, saying, why aren't you going against the principal debtor? Why are you going against me? But if you go through the guarantee bond, they have agreed and signed it, saying that the bank or the financial institution can go after them in the first instance. So, the bank or the financial institution is going to take a policy call as to who is best. So, assuming
who has the better capacity to
exactly. So, assuming the principal debtor cannot be found, or if the principal debtor is doesn't have any money, even if you file action against them, a bank or a finance company might perhaps explore the possibility of going against only the guarantors. And even if you look at a guarantee document, assuming you are a joint guarantor, that doesn't mean your liability is halved. It actually means that they can go against even one of those guarantors, assuming you have
for the total amount due.
Exactly. So, unless of course the guarantees specifically states otherwise. But going by experience of most of these documents that the banks and finance companies have, that is not the case.
That is so. Now, Janaka, another thing, obviously, that entire discussion takes us to the next area, which also is very important. At what stage can a company or bank begin the litigation process against a defaulter?
Most agreements will specify what a default is. If you go through, be it a loan, lease, hire purchase, factoring, overdraft, whatever, it will specify exactly what a default is. So, you can't, or I can't generally specify what a general default is, but generally it would say something. If it's a lease or a loan or a hire purchase, it will say perhaps non-payment of X amount of rentals or payments. If you take a large loan facility or a factoring facility, it will have a cap. Assuming you get a factoring facility, it will say, okay, at a point you exceed the facility amount, that will be the point they can go ahead and institute action. So, once again you need to know your limit in terms of assuming you default. You need to know that assuming the facility says that upon 2 defaults they can go in for litigation, you need to know that after the first default, the next one is going to be the point where the bank can take action.
Now, say for example that there is a default by the principal debtor on a lease agreement, and in terms of the contract or the lease agreement, default of 2 consecutive installments is grounds for the company to initiate litigation. And now litigation has commenced, and all the defences that have been put forward by the principal debtor and the guarantor have failed, and now it has come to the stage of judgment or whatever, and the company wins. Now we talked about the repayment capacity, right? Now if a judgment has been delivered in favor of a company or a finance company or a bank, how can the company thereafter recover those sums due? Is it necessary for that party thereafter to come and give the money to the bank? What is that process? Are they able to seize their property? What are the circumstances?
Unless there is an appeal preferred in relation to the judgment, the bank or the financial institution can take steps to what we call execute that judgment. Now, most banks or finance companies would have done their due diligence in relation to that customer there, where they would have an idea of what kind of assets or accounts or whatever that customer has. So, upon getting a judgment which is not appealed upon, they will take steps to execute that writ in relation to whatever assets they can get their hands on. So, you need to be careful in that sense. So, even if it's, I mean, it might be perhaps an ancestral property, for instance, but the fact that it is an ancestral property might not be an argument you can raise at that stage. So, unless of course, as I said, you have appealed on that judgment, but if not, the bank or the finance institution has every right to execute writ in relation to any of the defaulter's assets.
So, I think it's safe to say that one thing that we can take back from tonight's show is that before we enter into any kind of agreement or contract with a bank or a financial institution, we have to be very careful and exercise a great deal of caution and ensure that we know what we are getting into.
That's right, yeah.
And one way of doing that is to ensure that we are served with a copy of the agreement so that we can analyze as to whether we are in agreement with these. I think that pretty much covers a great deal of what we set out to do, Mr. Jayamahar, through this show. And by way of a summary, is there any parting advice that you can leave with our viewers?
In short, as I said, it would be to get advice before you enter into the transaction. Don't wait to go to a lawyer once the bank or the finance institution files action against you. And assuming that they do, even at that stage, you need to come to an understanding of what your rights are if you challenge it, and look at damage control mechanisms of even entering into a settlement if possible. So, it's very important that you get good advice firstly at the start, and assuming even if it goes in, if you are in default, you need to get proper advice as to even how you do some damage control at that stage.
Okay, so there you have it, ladies and gentlemen. I believe that we have covered the entire gamut of this area of financial products and what type of products we have recourse to that are available to us from banks and financial institutions. And we've also been educated on what our rights and obligations are when it comes to obtaining these financial products. And most notably, it is important for us to note that when we do enter into these agreements, we are sometimes thrilled that we've got the money into our hands,
True.
but we forget that we have to pay the money back. So with that, we have to close, but we will not close before thanking Mr. Jalmaha for taking time off his busy schedule to be with us this evening.
Thank you for having me.
Thank you for sharing the wealth of knowledge that you have gained over your many years in the practice. That's it, ladies and gentlemen. Thank you so much for joining us this evening. We look forward to having you once again next week when we will take on yet another interesting topic which is of practical importance to your day-to-day lives. Good night.